Hello, Judge Martin. Uta Birnbaum. I'm the one whom you just evicted me out of my 42-year, 150-acre homestead without letting me have a trial. I'm not a lawyer, Mr. Martin, but I know that one is entitled to a jury trial, even in the JP court, on a traffic ticket. The right to trial by jury is sacred, Mr. Martin. I don't know if you know that. But, hello, some of the other folks just tuning in right here. I need to give just a little bit of the background. I'm going to try to the essential things as to just exactly how Mr. Martin did this without a jury trial. And so I'm going to start, and I may be simplifying it a little bit, but I'll fill in the edges as necessary. Somebody out of Louisiana, and I will mention the name because it will appear again, a lady by the name of Lisa Girot, G-I-R-O-T, she pronounces it Girot, Lisa Girot, claiming to have inherited my property via essentially two estates. That means in this case from a friend of mine, which is Gwendolyn, died in 2006, out of that estate into the estate of her husband, Louis Thibodeau, and hence out of that by will to Lisa Girot, who was his court-appointed protector to protect him from somebody stealing from him. But let me recollect myself right here. But none of that happened. It was never in any of those estates over here. So but anyhow, she wrote up a deed to a Dallas land developer by the Robert Dow. The corporation was CSD Van Zandt. The suit against me was CSD Van Zandt. Well, what he did, the first thing I knew about him somewhere in the process, I had no knowledge of any of it until some surveyors showed up on my land and I ran them off, but I didn't know whose they were or couldn't find out anything. Well, it turns out it was Robert Dow. Well, the first thing I noticed over here, one of the lawyers called me and said they're the new owner of it and they wanted to know whose cows and hay was out here over here. They were trying to evict me as a tenant or something, but they didn't proceed with this. I called the law enforcement. They were on my property with a bulldozer. Actually, it's a skid steer that's sort of mowing trash cleanup. I called 911 several times to get them off. Couldn't get them off. That's another issue. Protection under the law denied to me. The next thing I knew that then I was served with a lawsuit where they filed suit in Mr. Martin, Mr. Martin, in your court over here for what's called trespass to try title. Anything that involves a dispute over title has to be in the district court. So they filed that, I answered that, and I made a counterclaim of real estate deed fraud. And in fact, I actually asked for personal protection from Mr. Martin for having discovered a giant real estate deed fraud scheme. Mr. Martin never did anything on that, but that's an aside. So the basic thing, to put it all together, what this is all about, somebody from Louisiana who does not own the property sells my property, somebody else borrows $850,000 from Sanger Bank, and goes through the title companies or who knows what, and nobody does any due diligence. And the next thing I know over here, I got sued in the 291st District Court asking that I be removed from my property over here and everything be turned over to them. And we go downhill from there, and there's a stack of paper in there for about a full year. I have a 7-page docket sheet, which I'm going to show. And that docket sheet is a record of the proceedings and the documents that were filed. And if one follows that one, it's much like not being able to see the forest for all the trees in the way. So I'm cutting this somewhat short to get to the essence of this. And the real essence of this is basically we have somebody sues me in the district court. We were in there for over a year over here, and suddenly Mr. Martin springs into action and on something that they laid in there, and it's really a plan. They put in a proposed order on something called summary judgment. Summary judgment is something to dispose a case where somebody sues you and you go to the judge and ask him to dismiss it. He doesn't have a case like negligence, you know. I might be negligent, sue somebody for being negligent for not painting his house green. Well, he has no duty to paint his house green, case dismissed. But there's another version of that where you look at the evidence, which is summary judgment. You say, Judge, he sued me over here, he doesn't, he's missing one of the elements, or there's something missing to which he has no evidence. The summary judgment should really be properly called to summarily dismiss. So we have summary judgment, which is really a summarily dismissal. It's a shortcut. And the other stuff, of course, is a judgment. A judgment comes out after a trial. You know, the plaintiff has to prove its facts under cross-examination by the defendant, and against his lawsuit, I'm the defendant, and I'm entitled to a jury trial, Mr. Martin. No, Mr. Martin. I'm not a lawyer, but the essence in this case is the essence of what Mr. Martin, did on this particular thing, to do all this stuff without a jury trial in there, when the right to a jury trial is absolute by the Texas Constitution. I may have mentioned this before. The right to a jury trial shall remain inviolate. I think it's Section 15 of the Bill of Rights of Texas. It's also, of course, under the U.S. Constitution, and so on, and so on. So I'm going to be focusing here mainly on how Mr. Martin did this thing without a jury trial in there, without denying me the right to have a jury, to even show my case, to present the evidence that they have no chain of deeds. They claim they have a regular chain of deeds. Land, the legal parlance for it is real property as opposed to personal property. Real property is land and things affixed to the land. And the title to real property in Texas can be transferred, or the word is conveyed, only by a deed, and the deed says from whom to whom, describes it. There's no particular form that needs to be followed, but it needs to identify from whom to somebody, him. That means that it's deeded from somebody to somebody else. Just so long as described what it is. It needs to be in writing, or at least have been once upon a time in writing, that there's evidence of that it had been there. And there's no other way to convey the title to real estate other than through a deed in Texas. They claimed a chain of deeds. My claim was they have no chain of deeds. Because the title was never in the first estate, was not in the second estate. The estate was not what's called administrated, so no deed can come out. A deed has to be from a living to a living. You can't deed something to a dead. There's something about probate which relates to entitlement, but you can't entitle a dead in this. Either over here, this one has a dead one over here who was named as an heir. You can't entitle a dead. Mr. Martin, something is real screwy about this whole stuff. So, with this as a prelude, and the key issues being, without a jury trial, evicted out of a district court which has no jurisdiction of eviction, send an 8-man officer crew. Mr. Martin, what the hell were you thinking you were doing? My life is in danger. Unless those folks are involved and told exactly what's going on, they were not. The sheriff himself was out there, pinned him down. Turned out he claimed he was being a witness. I put a sign on my door that said that this was unlawful, and I'm going to detail that in a little bit. Hello, Mr. Martin. Okay, now let me get into this. I'm going to show the documents right here. At least I'm going to be reading from them. This was prepared for my present appeal to the Texas Supreme Court. I've been through the 12th Court of Appeals in Tyler. All that stuff is on my website. This one was prepared for the Supreme Court, which I just mailed here about a week ago. Actually, the stuff to the Supreme Court is not an appeal, it's a petition for them to look at it. So the filing in the Supreme Court would be called a petition for review or something like that. I have not heard from them. I don't know what's going to happen to that, but I felt I needed to try this. I'm at an advanced stage of age. I had a stroke. I think the upper memory is stable, or else as crazy as it always was. The body is not exactly behaving. It's a thalamus stroke. It's a switching center between the upper and the substance. So you see me with a little speech problem, hearing problem, and a little fumbling problem on the documents. Here's document number 1. Mr. Martin, I'm going to describe it real quickly. Mr. Martin, there's three or four documents. The first document Mr. Martin signed was an order on granting them all relief requested. The other one is, on that one he issued a writ of possession. A writ of possession is really sending the sheriff out there and get him off the land. Here's a sign that appeared on my door when they evicted me as a tenant with 8 armed officers. I wasn't there, I had fled. I'm getting more details on this a little later. I posted a counterclaim on this stuff, telling them that their posting was unlawful because it didn't come out of the district clerk's office. It was signed by Mr. Martin himself, and he can't do that. Details on that later. I will read on a little bit more. Here is some of the damages that they did to me. This is all my belongings, my 42-year belongings, my parents' furniture. They stayed with me for about 6 years, from age 85 to about 93. It shows all the stuff thrown out in the ditch over here, and it shows the damages, just a spot check on some of the stuff, and the stuff in the bottom of the right is essentially my warning to the officers as it was posted on my door. It's a picture of this. The next one is the final judgment. I'm going to get into it a little bit more detail later. And here is the first page of 7 pages of the docket sheet. And I'm just reading the very first one. It's listed as a trespass to dry title, original petition, then it says jury fee paid, and it goes down the line. And actually these numbers on the bottom here are the page numbers of the appendix as I sent to the Supreme Court of Texas. So much for the reference. So now let me pause just a little bit and reflect. I was not trying not to distract too much with the details and come back into focus on what Mr. Martin did and how he did this. Hello, Mr. Martin. These few documents, because there was really not much output from the court except the number 1. He's of the opinion you ought to have it all, and then I think I'll send the sheriff out on that one over here and get Mr. Martin, Mr. Belmont out of there, and what he had to take his 150 acres with him, and then the judgment on that. And so let me now start out with the only document upon all the other documents in here are based. This thing is so irregular over here, it's hard to describe and put some sense into this, but this is a simple case that somebody basically denied me my right to a jury trial when I was sued, stole my 150-acre homestead, 42-year homestead, without a jury trial, sent the sheriff out of, let me get back to some mode over here. Forget the mannerism, I get enthusiastic sometimes. It says, the first document, order granting plaintiff's traditional motion for summary judgment. Now remember, I made the distinction between summary judgment and judgment. A judgment is, by the rule, the judgment shall conform to the pleadings and the verdict. That means for that to be a judgment, there has to be a pleading and a verdict. Pleading is what you claim in your suit. You can't get anything you don't ask for, and you can't get anything unless the jury is of the opinion that you ought to have it. So there's got to be a trial over here, Mr. Martin. You can't have a judgment without a trial in Texas over here. At least, got to be a trial. Order granting plaintiff's traditional motion for summary judgment on August 17, 2023. The case had been in there for about a year, a little over. Remember this date, August 17, it'll come up again and again. On August 17, 2023, came on to be considered plaintiff's traditional motion for summary judgment. The court, having considered said motion, in all responses and replies, if any, is of the opinion that the plaintiff is entitled to a judgment of law. Well, it's an opinion, right? And it's not very specific as to what he is about to grant. It says, it is therefore ordered, adjudged, and decreed that plaintiff's traditional motion for summary judgment is hereby granted in all things. Is hereby granted in all things upon the opinion of Mr. Martin. Mr. Martin, what happened about my right to a jury trial? This is your opinion. We have jury trials on the issues of fact, and there were a lot of them in here. We rely on the opinion of the jury. Mr. Martin, what is wrong with you? And again, notice that it's titled as an order. It doesn't say judgment on it. Remember, this 817 is an order, basically ordering everything based on, hello Mr. Martin, based on Mr. Martin's opinion. Okay, well now we come to the next one. Okay, I'll skip one over here because it'll just detract, it's important. Here, the next document, and it came out maybe about a week later. It says, writ of possession of the premises. That is eviction. That is a physical eviction. That's when you go to JP court and they evict you and tell you to get out. You get a judgment of possession. Landlord gets you out. And if you don't get out, then they send the sheriff out to get you out. So this is a writ of possession issued by the district court. District court can't do possession. Possession has to be by the JP court in Texas. It says, to any sheriff or constable in the state, whereas the plaintiff has recovered judgment of possession of the premises in the above titled and numbered action, and whereas the judgment was executed on August 17, 2023. Whereas the judgment was executed on August 17, 2023. I just showed you that document. It was not a judgment. It was an order. So this is a fallacy. It's fraud. Okay, now let's get to the wording over here. Whereas the plaintiff has recovered judgment of possession. Ain't no judgment of possession in here. And whereas the judgment was executed on August 17. Mr. Martin, judgments don't get executed. Yes, they get executed upon, but a judgment is not executed. A judgment is rendered and pronounced. The biting on this stuff, which is the writ of the writ of execution in a normal case when it's not a tenant eviction, is issued by the district clerk. Mr. Martin over here, this document over here, if you look very carefully, does not have a signature that it was actually entered into the records of the district clerk. Only the district clerk can issue a writ of possession. Well, the owner can issue a writ of any kind, Mr. Martin. Even on a bench warrant, it's called a KPS, the judge says to the orders the clerk to issue a writ of KPS, which says any police officer pick him up, but the biting is done by the clerk. In fact, Mr. Martin, there's such a term that's called to sign with the clerk. A judge can sit over there and sign his stuff, and it doesn't make any difference. If he signs it while sitting on the commode, it's not valid until such time as he signs with the clerk, which means enter it with the clerk. The file stuff and all output from the court, Mr. Martin, is essentially executed by the clerk of the court in her executive capacity under her own or her deputy's signature. Mr. Martin, judges can issue opinions, but they can't execute it. Use the police officers and use the clerk in the appropriate process. I don't know if you know that, Mr. Martin. Hello, Mr. Martin. Anyhow, here, this is his document on the writ. Notice that there was not something that was basically passed on. There should be no way for this document to get to the sheriff's office to execute upon if it didn't come out of the clerk's office. Something is irregular about this, Mr. Martin. Something stinks, something smells. Let me go on to the next one over here. Yeah, well, here's the signature on it, on the end of it. Can't see it from here, but it's signed by Judge Martin. The writ is not signed by a judge, Mr. Martin, okay? Writ is signed by the clerk, under the grand seal, the stamp of the clerk. All right, here's what showed up on my door, and I'll highlight and get a little bit more detailed. It says, warning, a writ of possession has been issued by the 291st Judicial District Court of Van Zandt County. All tenants and their personal property should be removed and blah blah. September 7, tenants and personal property remaining on the premises after that date and time will be subject to removal. The unit will be turned over to CSD Van Zandt. Okay, here. Now, the first thing over here, as a tenant, Mr. Martin, the law says the Justice Court, it turns out of the precinct, the Justice Court has jurisdiction over evictions. And if it says that over here, that means no other court can. In Texas, evictions have to be by the JP Court of the district. You can't evict me out of here, Mr. Martin. There's a tenant over here, beside the fact that I'm not a tenant. I've been in there for 42 years, Mr. Martin. And when you evict a tenant, you don't take the 150 acres along with it. Mr. Martin, something is screwy about this. Hello, Mr. Martin. Well, I counter-posted and alluded to that in just a minute ago, and I will read this in a little bit more detail, but it has the substance of it. This is my warning to any officers doing this, that this writ is unlawful, and I will read from it. Warning to any officer, be warned that I am not a tenant in a unit. He lives Udabumbum, a native-born Texan. I have uninterruptedly lived on my 40-year homestead. Any officer sent to execute be warned that this writ is unlawfully perpetrated on a color of law by signature of a judge, true writs, or on authority, seal, and signature of the clerk. Furthermore, this is unlawful because it is issued by district court, only the justice court, and then I have the case law over here, and execution is issued by the clerk. It's right underneath it, right over here. And it says, also says, eviction cases must be filed in the Justice Court of the precinct. I quoted that previously. It's right over here. Officer, you have a duty to not obey papers that you recognize or should recognize as being unlawful, particularly upon such specific and detailed warnings as above. So much for that. Here, I may have flashed this before. I think I did. This is the damage that was done to me with all my stuff on the roadside. This is the damage that did to all my stuff, and all got torn up in the process over here. And in the bottom right over here is an extra picture of this warning that I've counter-posted on my door for all the officers to see. Now we come to the final judgment. Strange that we have a final judgment over here after the writ of possession. Any kind of writ has to come after the judgment. As I said before, there was no judgment, so somebody had to fudge a judgment in over here on this one. Now let's read and look at the curious language in this judgment. Remember, the final output of the court is a judgment, and it's supposed to be upon shall conform to the pleadings and the verdict. That's Rule of Civil Procedure 301, I believe. Look it up. In fact, all of this stuff you can get on the internet if you know what you're looking for. It can stay there. It says over here, final judgment. On August 17, 23, the court granted all relief requested in something. That's an order, granting them everything. It says, in 27, and on August 17, it granted all this stuff. Specifically, the court grants judgment as a matter of law. Well, the judgment, we're talking about the granting. The language is screwball and strange. A judgment does not grant. A judgment declares. This language is screwball, Mr. Martin. Hello, Mr. Martin. The court grants judgment in matter of law. Nothing much more important on this. This one does have the clerk's stamp on it. As I said before, that writ was personally handled outside the normal procedure, inconsistent with due process. And again, here is the page 1 of the docket sheets. Now, let me put a little closing on this and collect my thoughts here a minute. I've tried to make this as simple as it is and focus on the key issues, and the key issues are that somebody claiming it writes something up, makes a claim in the court, files it, pays the fees, have a counter-suit fee in there, pays a jury fee, entitled to a jury trial, and none of that happened. It's all based on the opinion of Mr. Martin that they're entitled to relief on all the stuff over here. The writ of possession issued by a judge, you can't issue it. A writ is issued upon a writ of possession is issued upon a judgment of possession, which has to come out of the JP court, not the district court. Entitled to a jury trial no matter what. I'm not a lawyer, but I know that, Mr. Martin. Something screwball about this stuff, Mr. Martin. What were you thinking, sending all those officers out over there, endangering my life over there? Luckily, I had fled. Pardon me if I get a little bit enthusiastic about this over here. I'm about to turn 88 years old. Somebody thought and was told that I was a fuddy-duddy. Somebody believed a whole bunch of fables and who knows what. And everybody's involved in this, Mr. Martin. Not only you, but all the lawyers and everything. Let me make a comment over here. Mr. Martin, you come out of the criminal background. A couple of years ago back, and maybe 20, 30 years ago, Texas simplified the law on what's called theft. They had all kinds of frauds and who knows what. Now it's all called fraud, theft. Fraud is a theft. I'm going to now pontificate, I hate to use that word over this way, but philosophize, tutor on. Theft is defined as, in Texas Penal Code 31.003, I believe, theft is defined as the unlawful appropriation of property to deprive the owner of property. What's the wording exactly? Theft is the unlawful appropriation of property to deprive the owner of property. That's a criminal statute. But it's a pretty good definition of what theft is. It has the element in there, the legal, I'm not a lawyer, Mr. Martin, I don't know if you know this. It's called, there's something that in legal terms is called actus reus and mens. Actus reus, that means the forbidden act, I believe. Would you believe I took 2 years of Latin and never used any of it? And the other one is what they call mens rea, M-E-N-S-R-E-A, M-E-N-S one word, and rea, R-E-A. That means the state of mind or something like that. It's essentially the forbidden act and the state of mind which are both necessary for it to be a crime. It's not necessarily a crime to break the law. There has to be the motive in there. You ought to be familiar with that, Mr. Martin. And in that statute, there is a definition of appropriate, to unlawfully appropriate, as to there's a definition among Penal 31 something over there that defines appropriate in terms of certain context. Appropriate can mean, say, to take out of the Walmart without paying for it. But there's a special one in there that applies to real property. That means title and the likes. And the definition, I will repeat this very carefully. In the context of real property and titles, the unlawful appropriation is defined as appropriate means to bring about the transfer or purported transfer of title or other non-possessory interest in property to the act, whether to the actor or another. Now let me repeat that. Is to bring about. Now bring about, that means that anybody that's involved in bringing this stuff about is in on the theft, Mr. Martin. Okay. Theft is, in this context of real estate defraud, is to bring about the transfer or purported transfer. It doesn't have to be successful. To bring about the transfer of title to or other non-possessory interest in property. That says that title is a non-possessory interest in property. Now remember, possession is the J.P. court, Mr. Martin. I don't know if you know that. There was this, let me finish up there, I'll close up what I was about to get off on. The other answer is, or other non-possessory interest in property. That could be a lien on the property or something like that, or an easement or something. Whether to the actor or another, you don't have to steal it for yourself, Mr. Martin. If you steal it for others, you get the gist, Mr. Martin? Okay, anybody involved in this isn't up to a jury to decide who did the stealing and who's responsible for what of this sort of stuff. But I'll let you work that out, Mr. Martin, between you and the district attorney. This is theft, pure and simple, Mr. Martin, over here. And either you're in it or you permitted it, or I don't know, in between, or who knows what. But something is awfully screwy about this. Forgive me for getting up on my can this manner, Mr. Martin. But I have a mission on this particular stuff. May I forever be an albatross around your neck. What you did was evil. There's no other way to put it. Have you no conscience? Have you no shame, Mr. Martin? And the rest of the audience, forgive me for being maybe a little too hard on Mr. Martin over here. There was one more closing comment in here, which has to do with the penalties for theft. It depends on the amount involved. This one here involved at least $850,000. I think it goes up theft based on the amount, and I think past $300,000 it gets to be first-degree felony, and that ought to be enough to get somebody's interest, Mr. Martin. Hello, Town Curry, you're the district attorney. This ought to catch your interest. I complained to you also about this, and I didn't get you protection from this either. And hello, Mr. Joe Carter. I've also asked you protection on this stuff. Well, I didn't get it either, okay? I don't know where we're going to go for here, and I don't know what the Supreme Court's going to do upon this, but this is outrageous, Mr. Martin, and everybody else. Texas is full and ripe with real estate deed fraud by all kinds of, it's rampant all over, it's a pandemic. Now normally one goes back to the court to straighten this stuff out, but in this particular case it's the abuse and the use of the court itself to commit the fraud. This is asinine, Mr. Martin, this is un-American. Again said, forgive me for being so terse. I do have respect for your office, and it's important to maintain the perception of impartiality in the judicial process, because without the trust of the people in the judicial process we have no law, Mr. Martin. Well, it looks like we're close to having no law in your 294th District Court. Forgive me for having to say this way. But Mr. Martin, I see no other way out of this, and something stinks in your court. And you're either part of it, or it was pulled over on you and you were busy. You know, we got so many computers that nobody looks at anything anymore. And with having said that, regardless, oh, one more closing statement. I was told I reached out for some help. I was informed for clarity on this one as to relating to summary judgment and the difference. And the quote that I have from on high was to the effect that Karen, the district clerk, does not know the difference between a judgment and a summary judgment. It says, the district, Karen, does not know the difference between a judgment and a summary judgment, and unfortunately the judge does not know either. The district clerk does not know the difference between a judgment and a summary judgment, and unfortunately the judge, that's you, Mr. Martin, does not know the difference either. So all this stuff, all this taking of stuff, because I was unfortunate that you, Mr. Martin, didn't know the difference. So all this stuff is a result of you not knowing the difference between a judgment and a summary judgment. Mr. Martin, I think I was not unfortunate in you not knowing the difference. I believe I was fortunate in you not knowing the difference, because this thing would not have blown up like this. You knew the evil that you're fixing to do, but you did not know the difference between judgment and summary judgment, and how asinine the stuff was that you did, Mr. Martin. I was fortunate that you did not know. Think about that, Mr. Martin. With this again, may I forever be an albatross around your neck? If there be a hell, and if there not be one, let somebody build one. The world itself is already becoming a hell on its own. And Mr. Martin, may you forever sit on your perch over there and get hemorrhoids listening to all them crazy lawyers. I know you were not evil to start with, but you're evil now. Think about that, Mr. Martin. I have no personal animosity to you, but enough is enough, Mr. Martin. This has got to stop. And I have a mission to stop this. And your conduct, Mr. Martin, whether it's out of ignorance, native or acquired ignorance, is a menace to society because of your high position. You're a menace to society, Mr. Martin. Forgive me for having to be so blunt. Anybody else listening in? I have no animosity to the other one. The problem in America is education, and the solution is education. I believe the rules of civil procedure ought to be taught in high school. You understand that, Mr. Martin? You have some of the mock trials and other stuff that you conducted. I think there needs to be a push to teach the rules of civil and criminal procedure in high school, at least the rudiments or where to look for it. That's number one. And the next thing that needs to be done, in terms of equality, they need to knock a couple of pegs down off of that perch that you're sitting over there and put you back into the domain of ordinary human beings instead of sitting over there and thinking you're God. Forgive me, Mr. Martin. And with this I close. And may God give me strength, maintain my health. Good night. Amen.